Great that we're having law lecture series at the law library. I think it's a good way to draw people in. See, we have this law library and get people here. I have some former students in the back I see there. So hello to you. Thanks for the support. So I'm going to talk about Miranda. I think most Americans probably know Miranda pretty well. At least they know the right that Miranda establishes, the right to remain silent when you're being arrested or interrogated. And I'm going to talk about its place in the history of constitutional law and also, in the future, what's going to happen with Miranda. This is the 50th anniversary this year of the Miranda decision, and that's why the American Bar Association has chosen Miranda for these Law Day talks around the country. So, to start, I grew up in a college town, and that probably makes my experience a little bit different than some other people. For example, the first piece of graffiti I remember reading on a bathroom stall wall in a bathroom in the college gymnasium said, quote, God is dead, Nietzsche. And then it said below that, Nietzsche is dead, God. And I had asked my dad what that meant, and he told me it was supposed to be a joke. I've been reminded of that graffiti a bit in the last couple days, couple weeks really. Supreme Court Justice Antonin Scalia, who probably liked to make speeches in public more than any justice in our history, loved to go around and start his speeches by pounding on the table. He'd say, the Constitution is dead, dead, dead. Well, the other shoe has dropped, right? Now Justice Scalia is dead. Signed the Constitution, perhaps. What Scalia meant, of course, was that folks who believe in the idea of a living Constitution, one that changes and evolves, are stupid and probably dangerous, right? He argued, as you probably know, the Constitution's meaning is permanent, it doesn't change, and that it was fixed at the time that it was ratified. Only that fact, Scalia thinks, keeps us safe from activist-minded judges who would usurp our cherished freedoms. And we could probably debate the normative merits of Scalia's position, whether that ought to be how the Constitution functions all day. But as a descriptive matter, a matter of what the Constitution actually is in our legal practice, he was just plain wrong. The Constitution is very much alive. It changes, grows, decays, atrophies virtually every day. So with that in mind, I'd like to start this talk by asking you guys to imagine the Constitution as the banks of a big river with lots of braids and twists and turns. And our political and legal lives are like the water that gets directed through those riverbanks. The banks sort of channel and constrain that water. They constrain our politics and our daily lives. But in turn, the water of politics and life erodes the banks of the river, right? It displaces them. Certain very hard spots in the riverbanks, say like granite bedrock or something, may stand up to the water's flow for a very long time. They may change the course of our politics in pretty consistent ways for many years, but eventually they too will yield to the flow of the water. And new hard spots will be revealed as sediment is picked up and washed away and redeposited in other places. Now these hard spots, these sort of resilient granite places in the riverbank, are what I'm going to call the constitutional canon. But what I mean by that are sort of the documents and ideas outside of the Constitution itself that represent sort of the bedrock of our constitutional interpretive practices. Documents like the Declaration of Independence, the Gettysburg Address, Brown v. Board of Education, the Civil Rights Act, Martin Luther King's I Have a Dream speech, others, and I will argue Miranda v. Arizona is like those documents a part of the constitutional canon. Now, these canonical texts are things that any constitutional practitioner has to reckon with in the course of making a constitutional argument. I often tell my students that if your argument depends in court upon Brown v. Board of Education being wrongly decided, you probably need to come up with a better argument, right? Or a different argument. Now there can be a lot of different reasons why a text or a case becomes canonical, right? It might be particularly well written. It might capture something about who we believe we are as a people. It might inspire us to try to be better as a people. Or it might capture some kind of moment in time a cultural iconic moment particularly well. What matters is that the text captures something. I lost a page here. Hold on. You know what I'm going to do? I'm going to get into the 21st century here and go to the computer, like the rest of you would. Never done this before, so you have to stick with me for a second. So as I was saying, there are a lot of reasons why a text can get into the constitutional canon. It might be because it is really well written, or it might be really a popular expression of a particular constitutional idea. What matters is that it resonates somehow in our constitutional ear, that it settles into, right, our popular imagination as a nation and takes up long-term residence. When it comes to Miranda, there can be no doubt that movies and television, particularly police procedurals, right, have played a critical role in canonizing the case. The total ubiquity of Miranda warnings, right, you have a right to remain silent, anything you do say can and will be used against you in a court of law. The widespread television and film depiction of these virtually guarantees that the constitutional right that Miranda establishes is among the most well-known constitutional rights of them all. Again, if as a lawyer you find yourself in the position of having to argue that a suspect does not have a right to remain silent, well, I think you're in a tough spot. But as I have said, nothing is permanent in the constitutional canon. And even the hardest spots, right, wear away or change shape over time. Even Brown v. Board of Education, perhaps the most canonical case of them all, has dramatically changed its shape and position in the constitutional canon over the last 60 years. What once stood for the proposition that the enforced desegregation of public schools is necessary to afford all students the equal protections of the law, now, at least after the 2007 decision Parents Involved versus Seattle, seems to mandate that the state make no decisions based on race at all, even if that means we end up back in a very similar place to what we were before Brown, with de facto segregated schools. Brown has indeed changed quite a bit, and there are signs that the flow of our lives and our politics are reshaping the meaning of Miranda too, even as we celebrate its 50th anniversary. So what I intend to do in the remainder of my time here is to tell you the story, or try to tell you the story, of Miranda within our constitutional practice and the public consciousness or imagination. The problems that the case tried to address, the particular facts and circumstances of the actual case itself, the emergence of Miranda warnings in television, film, and popular culture, and the pushback against the decision that's been underway for a number of years in the court and elsewhere. And so without further ado, let me try to tell you the unfinished story of Miranda versus Arizona. Now, confessions have virtually always been an incredibly important part, but also a highly problematic part of criminal investigation and police procedure. This is so because the law, and particularly courts, have a really difficult time knowing how to deal with factual uncertainty. That is, unless a defendant is either caught red-handed doing the crime or later confesses, there's always some uncertainty about his or her guilt. Indeed, many times such decisions of guilt come down to the simple question of which witnesses are more believable or credible than others in a jury's mind. The fact that questions literally of life and death can turn on such subjective kinds of determinations is enough to make any judge or a lawmaker at least a little bit uncomfortable. And so for just these reasons, in early Western traditions, and here I'm talking most relevantly about the English law, courts initially turned over fact-finding disputes to God. This was accomplished originally by what was called the trial by ordeal, which usually involved fire or water. A defendant might be held underwater for a particularly long period of time or subjected to intense burning. And the theory was that if the defendant was innocent, then God would intervene on his behalf. That practice morphed into trial by contest, in which a defendant would be forced to fight to the death one of the king's chosen champions. You've probably seen this on Game of Thrones. And again, if he were innocent, right, the idea was that God would intervene on his or her behalf. And of course, as on Game of Thrones, if if you had enough money or influence, you could hire a champion to fight on your behalf. I'm not sure how the theology of that worked, but money talks, right? Beginning in the 16th and 17th century, however, English law began to move away from ordeals and contests and towards the evolving concept of the jury. I won't go through all the permutations of the self-informing, partially informing, ignorant juries that developed in England over the next couple hundred years, except to say that, as most practicing trial lawyers can attest, a jury decision may be no more rational than a trial by fire or contest. Even with the jury in place, then fact-finding remains something of a black box, right? Information goes in, something mysterious happens, and a verdict comes out. And judges, of course, are loath to revisit a jury's factual determinations, and it probably remains just as advisable as ever for a defendant to ask God to intervene on his or her behalf while the jury deliberates. And hence, they have the modern prevalence of the plea bargain, right? Strike a deal before we have to submit anything to the jury. Which, to get back to the point, is what makes confessions such an important part of criminal prosecution. It just makes everybody feel better if there's a confession, right? The police and the prosecutor feel less anxious about what the jury might do. The judge feels better about imposing a sentence on a criminal who's admitted to the crime. And so accordingly, in 16th and 17th century England, when juries first started up, there were absolutely no restrictions on the admissions of confessions into trial evidence. And in practice, they were usually actually the equivalent of a guilty plea. If you had a confession, often a trial was not even necessary. Perhaps unsurprisingly, it was also a matter of common practice to beat or torture confessions out of suspects up through the middle 17th century and beyond. This began to change a little bit during the reign of Charles I, however, in England, not because he was a particularly liberal king, but in fact just the opposite. He was so notoriously repressive of his critics that a popular swell brought in a number of reforms, including the idea of some kind of protection against self-incrimination. Now, this was clearly more theoretical than substantive for most of the next century, as courts, as a practical matter, still allowed virtually all confessions in. In fact, there's no record of any confession excluded from evidence in England until the year 1775, on the very eve of the American Revolution. And it wasn't until some years later, 1783, which was the end of the American Revolution, that a court first gave a clear statement of a rule excluding confessions that were elicited through brutality, threat, or promises. Even so, following that doctrine, in practice, very, very few confessions were actually kept out of court. The Fifth Amendment to the United States Constitution, of course, elevates the right against self-incrimination to the status of a basic and fundamental right. Even so, it wasn't until the latter half of the 19th century that American courts began to call the circumstances of many confessions into question. And when they did do that, the focus of their concern was generally what was called the third degree type of confessions or interrogations, as in, give them the third degree, boys, right? You've seen that on TV or in cartoons somewhere. The most common legal sanction, right, for overly aggressive interrogations was to exclude a confession from evidence. But things had to be pretty bad for that to happen. Several cases in the late 1800s are illustrative. In Hopt v. Utah and Hansen against the United States, the Supreme Court suggested that innocent people are not likely to confess, but allowed that we might call some kinds of confessions into question if they're obtained by violence, threat, or promise. But prolonged confinement, for example, even in irons, was not enough to toss a confession out. A third case, though, Braham versus the United States, finally made the connection explicit between the third degree, these kind of interrogations, and the Fifth Amendment's protection against self-incrimination. It wasn't until the 1930s, though, that the modern doctrine of self-incrimination really began to take shape. In one particularly notable case, called Brown against Mississippi, a white landowner was found murdered, and a local mob then rounded up his 3 black tenant farmers. One of these tenants denied any involvement in the murder, despite being twice hanged from a tree limb, but he finally gave in after being repeatedly beaten with a leather whip in a jail cell. The two other tenants were also whipped mercilessly in jail until they confessed. The Mississippi Supreme Court, perhaps unsurprisingly, twice upheld these convictions based on these confessions that were clearly coercive, but the United States Supreme Court reversed and excluded, as a matter of law, any confession obtained by brutality or violence. In 1940, in Chambers against Florida, the court extended this reasoning to a different, non-violent, but plainly coercive scenario in which a bombing suspect was deprived of sleep for 5 straight days of intensive questioning before he finally gave in and confessed. Until the 1960s, however, the court was pretty inconsistent about what types of questioning beyond violence violated the Fifth Amendment. 36 hours of uninterrupted questioning was too much, for example, but 11 days of solitary confinement was okay. And it wasn't until the Warren Court revolution was pretty well underway that the court began to take a more consistent or principled approach to the question. And the principles that began to emerge centered around the idea of the voluntariness of a question, that is, whether or not the confession was made against the suspect's will. And that question came to depend upon an assessment of the totality of the circumstances surrounding the arrest, the confinement, and the interrogation. This holistic kind of approach still produced some pretty disparate kinds of results, based largely on the sympathies of particular judges and justices and the circumstances in particular jails, and as a consequence, it left the police in something of a difficult spot. They needed to work hard to get voluntary confessions, but they could never be quite sure what types of tactics or questioning might later prove to have been too aggressive and get a confession excluded. Which brings us to the Miranda decision. The case arose out of a rape in Phoenix in 1963. An 18-year-old movie theater concessions clerk was kidnapped on her way home from work, taken into the desert where she was raped and robbed of the $4 that she had. And rapes, as it turned out, were way up in Phoenix that year, keeping with a decade-long trend in the city. And in the popular press, this explosion in sort of crimes was blamed in part, at least, on the chilling effect that the court's inconsistency was thought to have had on police interrogations. The girl in this case described a Hispanic man driving a large Packard as her rapist. A relative got the license plate number of a car matching her description, which turned out to be registered to a woman who was friends with Ernesto Miranda, who was, of course, a Hispanic male. Miranda had a long criminal history, including a conviction for assault with the intent to rape, and the inside of his car matched up pretty well with the girl's descriptions that she had given the police. So the police put together a lineup with 2 other Hispanic men and brought the woman in to try to identify Miranda, but she could not definitively identify him as her assailant. The frustrated police then took Miranda back into an interrogation room where he asked them, "How'd I do?" "Not good, Ernie," they responded. "Did she identify me?" he asked. "Yes, Ernie, she did," they lied. At that point, Miranda said, "Well, I guess I better tell you about it." No attorney was present, and the subsequent confession was neither recorded nor witnessed by anyone but the police officers. Those officers would later say that Miranda voluntarily confessed not only to the rape in question, but also to several other assaults and robberies. They gave Miranda a prepared statement about his voluntariness to sign, and he then wrote an account of the rape that matched up pretty well with the victim's description. They then showed Miranda the girl through the glass, and he confirmed that she was the one he had raped. On the strength of this evidence, Miranda was indicted and tried for both the rape and an earlier robbery. The trials for the rape and the robbery were held separately, but the confession was at the center of both of them. Now, Miranda's lawyer, it turned out, was not very good. In fact, he was pretty bad, but it probably wouldn't have mattered if he'd had somebody better. He received 20 to 30-year concurrent sentences for the robbery and for the rape, and he then appealed first to the Arizona Supreme Court, arguing, among other things, that the confession should have been excluded because it was obtained without an attorney being present. While his case was ongoing, the United States Supreme Court had thrown out a confession in another case called Escobedo versus Illinois, in which the police had denied a suspect a lawyer even though he had repeatedly asked to have one appointed. The Arizona Supreme Court distinguished Miranda's case, however, because he had never even asked to have a lawyer. The state court concluded that a confession made without an attorney is okay so long as it is voluntary, which is what the law of the land looked like at that point. And Miranda, of course, has signed an affidavit saying that his confession was voluntary. This would likely have been the end of the road for Miranda if it weren't for Arizona ACLU counsel Robert Corcoran, who would later serve on the Arizona Supreme Court. Corcoran saw in Miranda an opportunity to sort of incrementally expand what the court had held in Escobedo. He hired on two prominent attorneys, including, I have to note, a constitutional law professor, who took the appeal all the way up to the United States Supreme Court. The gravamen of their argument was that uneducated, ill-informed, and indigent people like Miranda might not know that they had a right to ask for a lawyer. And, thanks to another freshly minted Supreme Court decision called Gideon versus Wainwright, they actually had the right to have that lawyer appointed free of charge. These rights could only exist, Miranda's lawyers argued, inasmuch as a suspect knows that he or she has them. They therefore argued that the court should adopt a rule whereby the police must inform a suspect about his or her rights before questioning begins. As you probably know, a 5-4 majority of the court, close split, led by Chief Justice Earl Warren, largely adopted Miranda's attorney's recommendations, holding that the police must tell suspects 5 things before questioning. First, you have the right to remain silent. Second, anything you do say can and will be used against you in a court of law. Third, you have the right to an attorney. Fourth, if you cannot afford an attorney, one will be appointed for you free of charge. And 5, if at any point you wish to terminate the questioning, right, you may do so. The dissenters, there were 4 of them, and many law enforcement officials worried that the court's decision would severely handicap police interrogations moving forward and result in fewer prosecutions and more crime, etc., which, for reasons I'll discuss in a moment, turned out not to be true. Miranda, for his part, had his conviction overturned, and he had a new trial ordered. He was subsequently convicted again for both crimes based on new evidence and the old non-confession evidence, and he spent his life in and out of jail and eventually was killed in a knife fight in 1976 in Phoenix. The Miranda warning, however, quickly became a fixture in American popular culture. Jack Webb, the producer of the hit TV show Dragnet, who was known for his obsession with getting police procedure exactly right, incorporated the warnings into the series for the following season after the decision. And so for years afterwards, Joe Friday, who if you don't know is the show's main character, would issue Miranda warnings, right, to the nation, to the TV audience in the nation every week. This was picked up in other shows and movies to the degree that by 1999, when the court actually considered overturning Miranda, constitutional law scholar Akil Amar wrote in the LA Times, "For better or worse, Miranda has been woven into the fabric of daily life, into the standard operating procedures of police departments around the country. Overruling Miranda cannot take us back to the world that pre-existed it, even if we wanted to go there. We have all been Mirandized too many times, even if only on television." And in the court's decision in that case, which was called Dickerson versus the United States, Chief Justice Rehnquist observed that the warnings have, quote, become a part of our national culture. Miranda had been truly canonized in the constitutional literature, as I've been talking about. It's become a hard spot in that riverbank, it turns out, both because it provides a consistent principle and because of popular films and TV. The next 20 years saw some alterations to the Miranda rule, though early on at least, these were generally made to sort of increase the scope of protection for suspects. For example, in 1981 in Edwards against Arizona, the court held that police have to immediately stop questioning any person who clearly expresses a desire to have an attorney present. But by 1994, the composition of the court had changed, and Miranda's expansion not only sort of came to a halt, But really, indeed, the worm began to turn and people began to push back against Miranda. In Davis versus the United States, the court declined to extend the Edwards rule to instances where a suspect waffles about getting a lawyer. In that case, saying, maybe I should talk to a lawyer, was not enough to require that the questioning stop. And in a particularly brutal case decided a few years later, Chavez against Martinez, a policeman coercively badgered and denied medical treatment to a man that he had shot 4 times with the hope that he would say something to justify the shooting. The Supreme Court held, however, that Miranda did not apply because no charges were ever filed against the man, though he remained blinded and partially paralyzed for the rest of his life. This and other cases slowly eroded Miranda's spirit and reach through the 1990s. And by 2000 then, when Dickerson against the United States made its way up to the court, many observers wondered aloud, quite prominently, whether the justices were in fact prepared to jettison Miranda entirely. The facts of Dickerson are pretty straightforward. A bank robber was captured and interrogated without being read Miranda warnings by the FBI. He confessed during the interrogation, but later he moved successfully to have the confession excluded because he didn't get his Miranda warnings. The government's defense in the Fourth Circuit Court of Appeals, though, was potentially revolutionary. It relied on an old statute, one passed in 1968 during Nixon's push to restore law and order, that essentially sought to overturn Miranda by making the admissibility of confessions depend solely upon their voluntariness, which had been the law before Miranda. The law was intended, of course, to overturn Miranda by statute. The trouble was that virtually no one noticed. The law was virtually ignored by law enforcement officials, largely because most of them believed that it was unconstitutional, until government lawyers unearthed it 30 years later in Dickerson. Indeed, when the Dickerson case actually reached the Supreme Court, Attorney General Janet Reno actually argued in support of the defendant's position. The Fourth Circuit, however, concluded, I think somewhat mysteriously, that Miranda was not, in fact, a constitutional decision, but rather a matter of statutory interpretation. I say mysteriously because Miranda expressly roots its holding in the Fifth Amendment, and virtually every practitioner has understood it as a constitutional decision for the last half century. But the Fourth Circuit disagreed, and because Congress can overrule a non-constitutional decision by statute, they held that Dickerson's confession was admissible. The Supreme Court, in a perhaps surprising 7-2 vote, reversed and upheld Miranda. Chief Justice Rehnquist, as I said before, concluded that the decision was just too embedded in our popular consciousness and culture to overturn. He also, of course, sharply criticized the idea that Congress could second-guess the court's interpretation of the Fifth Amendment, saying, quote, "Congress may not legislatively supersede our decisions interpreting and applying the Constitution." In truth, however, despite the early fears of the dissenters and law enforcement officials about the negative effect that Miranda would have on investigation and prosecution, much of the police community has actually come to support the Miranda decision. That's because, in effect, Miranda is actually probably as helpful or more helpful to the police than it is to a detained suspect. It gives the police a clear rule to apply, and it actually gives them something of a talismanic kind of defense against later claims that the interrogation was coercive. If the suspect has been read his or her Miranda rights, then a subsequent confession is likely to be admitted into evidence, even if the questioning that then followed the Miranda warnings turns out to actually have been quite coercive. I don't know how many of you have seen or saw the recent Netflix documentary entitled Making a Murderer. Probably a lot of you. I couldn't get past the 4th episode myself. It was just a little bit too frustrating to watch. But in that film, the directors got hold of the video recordings of the interrogation of 16-year-old Brendan Dassey, a suspected accomplice in the murder in question. And Dassey is not a bright kid. He has a low IQ, possibly around 70. And it's clear that he has no idea what the consequences of his admissions to the police might be if you watch the film. The police repeatedly put words in his mouth to get his story to match their account or theory of the case. And after Brendan actually admits taking part in a brutal murder, he simply asks the officers, "Can I go home now? I have a project due in school tomorrow." "No, Brendan, you can't go home," right? Dassey, though, was duly read his Miranda warnings, and so any effort to exclude the confession likely faces a pretty steep challenge. As an aside, a lot of pop culture figures, Nancy Grace and people like that, have come out bitterly against that movie, against the documentary makers of Making a Murderer, saying that they presented a very one-sided view of the case and that the people convicted were almost certainly guilty of the crime anyway. That, of course, entirely misses the point. First of all, documentarians have no obligation to be fair and balanced, unlike some news stations, and their makers are clearly trying to make an argument, which is what nonfiction authors are doing all the time. Second, and I think much more importantly, the defendant's guilt or innocence is simply not what troubles so many people about that case. What rightly troubles them is that the way that the police and the judges behaved and were captured on film. So the question the film really presents is not so much whether Stephen Avery is guilty, but whether the police and courts in Wisconsin are. And I think there's pretty little doubt on that score. But back to Miranda. As I said, despite some serious worry in 2000, the court reaffirmed the decision in Dickerson against the United States. It did so, however, largely because of the canonical place that the case has come to occupy in sort of our popular imaginations and consciousness, which, as I have said, has been fueled in no small part by the prevalence of Miranda warnings in movies and television. Interestingly, however, that television presence has also begun to fade away. As just a quick and dirty sort of comparison, in the first season of Dragnet after the decision, that's 1967, 27 arrests were depicted. In 25 of those depictions, the police read the defendant or the suspect their Miranda warnings. In 1990, however, in Law and Order, they showed Miranda warnings read to just 20 of the 39 arrestees. By 1993 in NYPD Blue, only 12 of the 68 suspects arrested were read their rights. In 2000, just 3 of the 52 folks arrested on CSI got Mirandized. And in 2006, on The Shield, just 3 of 63 suspects arrested were read their rights. So what does that mean? Maybe nothing, I don't know. But I do suggest that it's possible that the same forces that sort of ensconced Miranda so firmly in the constitutional canon may in due time wash it away, right? TV made the case what it is to most Americans, and TV, or maybe it's the internet or social media, who knows something now, maybe what brings it down again in the end. After all, even the court acknowledged in Dickerson, when it saved Miranda, they did so largely because of its place in popular culture. And as that begins to fade away, perhaps so does the rationale for keeping the Miranda decision in place. So to conclude, and then I'll let you ask some questions. Since 1966, Miranda has occupied a preeminent place in the constitutional canon, which, as I've said, are those texts outside of the Constitution itself which sort of shape and direct our constitutional, legal, and political practices. But the canon is not permanent or unchanging, right? Indeed, it evolves a great deal all the time, particularly as circumstances, particularly as justices change on the Supreme Court. And Miranda has not always proven to be the great protector of individual liberty and suspects' rights that some thought it would be. Okay? The court has eroded some of its substance over time, and in practice, Miranda warnings have actually come to protect the police as much or more than suspects. What's more, Miranda made its way into the canon on the back of television and movie scripts, and it's pretty clear that the case has lost some of its place and presence there as well. For a younger generation, those that don't remember Dragnet or Adam 12 or even Hill Street Blues, the ubiquitous "you have a right to remain silent" is beginning to fade from the television presence. And when it does so, so may the cultural protection that the case enjoyed the last time it was challenged in the Supreme Court in Dickerson. And who knows what happens then. So happy 50th anniversary, Miranda. Let's hope for at least a few more years to celebrate. And I'm happy to try to answer any questions you might have. Or anything, it can be about anything.
I have
Sure.
I have a case. This is the scenario. It's a nephew,
Okay.
and he's mentally retarded.
Okay.
And he was arrested for aggravated assault on that's aggravated sexual assault on a minor.
Okay.
Okay, they went to trial, he was charged, he was sent away to prison.
Mm-hmm.
And I didn't know much about it because this is in Texas and I live here.
Sure.
Well, recently in January, January the 5th, after he had served time and all that, he came home. And then again, he was living at home. He was sent to a prison, to a halfway house, and then he was released and sent to my brother's care, his father. Okay, so he was at his house working with the Salvation Army and that kind of stuff for 17 years.
This is after he came back
Yes.
here? Okay.
So he was home working and stuff. Okay, so after that, now again in January the 5th, the police came over and arrested him. Okay, now this is what brings me here to ask you.
Sure.
Okay, he's arrested. He, like I said, he's mentally retarded. He can't speak very good. His parents speak Spanish to him, so he don't understand too much English.
Okay.
And so the police come and they arrest him and they read him the Miranda. The nurse that was at the house because they were taking care of his mom who had a stroke. She explains to the police officers that he doesn't understand what they're saying, and especially because they're speaking English. So they told her to leave. You need to leave because we want to talk to him. My brother is at work, so there's no one else to help him. So he gets arrested. And I look at the police, now I became involved, because, so now I look at the police report. The police report has the wrong name, has the wrong age, but had the right address. So the thing.
So they have the wrong guy, you think?
We explained to the lawyer, that they had the wrong person, but they had the right address. And
Or they had the wrong address.
so we brought it to court, and as like the Miranda says, you have the right to an attorney. Well, there was an attorney that was assigned, and we kept telling him, you have the wrong person. You have the wrong person. And he kept telling my brother, he says, you have a sick wife, both of you are older people. If you want us to release him in your charge, you're gonna have to sign guardianship papers. And someone says, what do you mean guardianship? I'm his father, and he's been with me for, all the time. And so what I'm trying to find out is where was the mistakes made, or how can we correct, or how can I help them?
Yeah, okay. Well, so there's a number of questions now that you need to figure out factually what happened. So, first of all, was he ever charged with anything?
He was charged, he was sent to prison, and then from prison to a halfway house.
No, but I mean this time around, after the police came.
Oh, this time? No, because we intervened and we said, you have the wrong man. Look at the police report. A lawyer was assigned.
Okay.
I guess their agency is named Moore, M-O-H-R, from San Antonio. Okay, so I sent him a copy of the police report showing the information was wrong. And then also, I sent him a copy of his ID, his social security, so they could find that it was wrong.
Yeah. So essentially, they got the wrong address when they went out to arrest
They had
somebody.
the right address, but everything else was wrong.
Well, I mean, it was to somebody else, but they went to the wrong house, right? So he was never charged. Did they tell you why they were arresting him? What the suspicion
They
was?
sent him to the holding cell in Laredo, Texas. That's where where he lives.
Okay.
And from there he was transferred to San Antonio because that's where the case was brought up, and that's when it happened.
Okay.
And
So what was the arrest for this time around? You don't know.
Because the computer report, or but I think what the police went by was it said that he had committed aggravated assault, that there was a bond, and that he had jumped bail. none of that happened.
Right.
So,
So this is just a bail. This is a
yeah,
bail violation
and
arrest.
now we're trying to get another lawyer
Yeah.
because we have witnesses that he never did what he was charged with.
Yeah.
The wrong name and all that, and also that he was held in San Antonio. Like I said, brought him to San Antonio, and then this lawyer was, and I told him, so you have the wrong man.
Right. And so what did the court do? Did they eventually let him go?
Well, they were holding him.
Mm-hmm.
In the meantime, his mom died.
Okay.
But she had come down with a stroke,
Mm.
So his mom died, and so my niece, another niece, was working with the court, with the lawyer, and she said, I'm taking him to Laredo, because this is, he's being held in San Antonio.
Yeah.
She said, I'm gonna take him to Laredo, his mother just died, and if you want to arrest him, then you're gonna have to arrest me too, because I'm taking him to his mom's funeral. So, and now they have assigned like a social worker,
Okay.
so he's like an in and out type of
Right.
prisoner, I guess.
It's like a halfway house now. Based on this most recent arrest, they've
Yeah,
put
so
him in a
we're,
halfway house.
so what we're doing is we're trying to bring the witnesses, we're gonna go to
Okay.
court,
Sure.
have a hearing, bring the witnesses, there's 3 witnesses that can prove that
Yeah.
he didn't do that.
So it sounds like there's 2 problems. One is, right, the Miranda warnings were inadequate, right, because he clearly didn't understand them, right? So in many jurisdictions, if you look at the police card, the police procedure is actually to ask at the end of each of those questions, do you understand this right? So it'll say you have a right to remain silent. Do you understand this right? And they have to get an affirmative answer to that question, right? Sounds like that didn't happen here, but the court has held that we have to have some evidence of actual understanding, otherwise the warnings would be sort of useless. Now, I don't know what kind of interrogation they did of him after the Miranda rights, if he admitted to anything or anything incriminating came out, or whether they denied him a lawyer and he asked for one, right? But if any of those things happened, those would certainly be questionable based on the Miranda readings. It sounds to me like he hasn't been charged, though, and the court has held that unless, right, you're charged, right, and actually have to go to trial, the Miranda warnings it doesn't matter, right, because the confession's not actually being used against you and they say no harm done. But it sounds to me like the bigger question you have, right, is how this mistake happened, because it sounds like it's a case of mistaken identity. And it sounds to me like they had a name, so they said the name wrong, they had the age wrong, so they were looking for a different person. They just got the address wrong on so they went to the wrong house, and they got your nephew. Now, how that mistake happened, I'm not sure you're going to be able to uncover that. I think you can certainly, hopefully, demonstrate that it's a mistake if there's still some outstanding case being brought against your nephew. We can demonstrate with witnesses or whatever else that it's a mistake. I'm not sure. Maybe Amy Rose is going to speak later on behalf of the ACLU, can give you better information on how you might actually go about finding out, if you can, what happened in police procedure that ended up with these folks at your house. Is that helpful? So on the constitutional question about Miranda, I think you have a great case. If he clearly didn't understand the rights, I just don't know what the harm to him right now is of having the inadequate Miranda warnings.
Yeah,
if some harm comes up, then you can sort of talk about that.
Yeah, there's other stuff involved too. And I also wanted to ask you, is there a Miranda that a police, for a disabled person, because, like I was looking in the computer,
Yeah.
and it says that there is the one where it says you have the right to remain silent, anything you think, let's see, no, this is not the one. I think this is, where it's, I probably put the wrong one here. But anyway, it's written out for a disabled person.
Okay.
And I don't have it here. I think I gave it to my brother.
Yeah.
But
Or
there is-
translated into Spanish.
Yeah, it's a Miranda right, and it says I'm mentally retarded, I cannot speak, and I cannot
Right.
communicate. if you touch me, I might get aggravated, or
Right.
bright lights kind of get me.
Freaked
So
out.
is there,
Well, I'm sure
that
that,
I
I don't know
can-
the actual Metro police procedures. I'm sure they do have procedures for that sort of thing, because again, they want to err on the side of caution and make sure generally that they get the Miranda warning understood. What I think is important, though, is that, as I tried to sort of bring out in the lecture a little bit, it's not, Miranda does not solve everything, right? Just because they read someone the Miranda rights doesn't mean that the questioning might not be coercive thereafter. The court is still going to look to the totality of the circumstances surrounding any interrogation or confinement and see if other things beyond not knowing you had a right to remain silent or a right to a lawyer could still be other things that are coercive, right? And so, you could still beat a guy after that if you wanted to, right? And we would want to exclude that. So the inquiry doesn't end with just what particular Miranda rights were read to your nephew. The inquiry also would include things like his mental retardation, his lack of speaking English, what the police officers did when they pushed the nurse out of the room. All that kind of information would be relevant to whether or not anything he said was sort of coerced out of him. Again, though, it's going to depend on whether he said anything and any harm has actually come from the questions or whatever the police asked him. At this point, it sounds like more of the harm is just the fact that police showed up, got the wrong guy, and caused a bunch of trouble, right? Is that fair to say?
yes.
Yeah, and again, I'm not sure how you root out what the cause of the problem was in the police department. And again, maybe Amy can talk more about that, but the constitutional issue, I think you have a good case, but you don't actually have the harm yet to go forward on that. In the back, yes.
That's Bartrum. I just have a couple questions.
Oh, good.
So some developments in Miranda.
Yeah.
Just wanted to hear kind of your take on it.
Yeah.
One, nationally, Supreme Court, I think it was in a case called Salinas, says that you don't have the right to remain silent unless you say it out loud. So unless you say, I want an attorney, you don't have the right to remain silent. And second,
Unless you say I want to remain, unless you say I want an attorney out loud, you don't have the right to an attorney. Is that what you're saying?
and or say, I want to remain silent.
Right.
I want to exercise my right to remain silent. You
Yeah.
don't have the right to remain silent.
Yeah.
And then locally now, a couple federal judges have thrown out Metro's Miranda card, saying it's unconstitutional. Because the
know that.
Metro Miranda card doesn't say you have the right to an attorney before questioning.
Huh?
And so now they're saying, people are assuming you only have a right to attorney
Right.
if we charge
If
you
we go to
and
court.
further.
Yeah.
But in fact, they're now saying you really have that right to attorney
Yeah.
before we even question.
Yeah, and that's in the language of Miranda itself, that it says before questioning begins. So I didn't know that about Metro. That's interesting. It seems like it would be a good challenge. Yeah, and on Salinas, it's interesting. That is, I think, a further evidence that there's sort of this erosion of Miranda, right? I talked about Davis, right, where the court said if you waffle, right? It used to be basically if you said attorney, I want an attorney, I might want an attorney, that was it, right? That was enough to trigger the Miranda. Davis, the court said, no, if you're kind of equivocal about it, right, don't need to get him an attorney. You have to be very clear and express, okay? And that's sort of the same extension, I think, as Salinas, where now that you have to say, I want to remain silent, which is, oxymoronic in some way, right? Or I clearly want to have an attorney, which is, I think, as I say, further evidence that at least the spirit of Miranda is being pushed back. Again, as I've said, though, I don't think police are generally opposed to Miranda. I think in general, most people know Miranda anyway. They know, or at this point, a lot of people know it. It's not as though I think it actually probably hinders criminal investigations a great deal to read rights anymore. And in fact, as I say, it offers something of a defense, right, against later questioning if you read them the Miranda rights. People are less likely to, but good questions. Yeah.
I hadn't, Professor, thank you, by the way, I enjoyed the presentation, it was excellent, thank you.
Yeah.
I hadn't really thought, until you said it, I really hadn't thought about it, but you get away from the voluntariness argument, and we don't get to look at things like the read technique, and can police be lying, because we have Miranda, and sort of that's the threshold question, and once we get past that, then everything else after that is fair game, and I really hadn't thought about it in that way until you said that.
Yeah, and I want to be clear, it's not that everything else is fair game. We still can question those things. The law is still going to be the totality of the circumstances, but in practice, right? It's often very much more difficult to make a case that, you know, the confession was not voluntary when you've been told you have a right to remain silent. You've been sort of flashed my talisman and told you that. Now it's very hard to question voluntariness, right? Even based on the totality of the circumstances, or at least much harder. Much fewer cases are probably successful.
So it's a separate line of questioning.
Sure.
On lying to suspects.
Yeah.
Or,
well,
you know, the
right. It's still will be analyzed within the totality of the circumstances, which is everything that happened, right? Lying will be a part of that consideration, right? But at the same time, if you've been read your Miranda rights and you know that you don't have to say anything, and you can have a lawyer there, and your lawyer's not going to let you say anything, that factors into the totality of the circumstances also, right? And makes, I think, it much harder to make the case that, you know, I was totally fooled. I didn't know I was coerced into this, right? Even if things could be quite coercive, right? As you say. And that's the case in Miranda. They lied to him, right?
Right.
Said, oh, she ID'd you. Sorry, buddy.
Yeah.
Better talk.
Yeah. And it becomes difficult to teach to students
Yeah.
who are first-time juniors in
Yeah.
hie school in criminal
Yeah.
justice. This seems to be a contradiction in what we think about
Right.
law enforcement in general, and it's quite an eye-opening, I think.
Yeah, I'm interested to hear what happens with the federal suits and with Metro. I mean, clearly that's wrong. Whatever on their card is wrong. How it got to be wrong is an interesting question, right? Whether it was deliberately made to be wrong or just
So
a
federal
mistake.
Judges are throwing out the cases based
Yeah.
on the record. The district court judges, you've got one who's thrown it out, agreed that it's wrong. But in justice court, where most of the action happens,
Status quo.
there's no doubt.
Huh. Well, you would think if the federal courts do it, eventually that it's going to have to trickle down to the justice court, but that may take some time. Well, very interesting. Any other? Yeah.
Say you question someone multiple times, like I question you one day and 2 days later I question you again. Do I have to read you Miranda both times?
Usually the police will do that, yes. I mean, it's not clear in Miranda itself, but yeah, that's the practice. It's like, I don't know if you've been arrested multiple times or questioned multiple times, but no, just kidding. But yeah, as I say, it's better safe than sorry for the police. Yeah.
Could you talk a little bit about your background, how you came to come into practicing constitutional
Sure.
law, and
Sure.
a little bit about...
Yeah, so I'm from Vermont originally, about as far from here as you can be. And I was a high school teacher for many years, not many years, 5 years. And felt like many years. And I taught in DC, in Washington, and eventually decided I was interested in teaching at sort of a higher level, and so I decided to go to law school. I then went and clerked for several judges, some trial judges, and then also state Supreme Court judges, and then basically went straight into teaching from there. So I got hired back to the law school that I had gone to, which was Vermont Law School, and then I was interested in constitutional law all the way through, just sort of, I think, a lot of people are. I like history, philosophy, I like sort of criminal procedure, that kind of stuff. And then I was fortunate to get into an advanced degree program in law at Yale. And from there, just kind of followed the long road into the teaching profession up here at Vegas. And I don't actually do a ton of practice. I do some consulting with different groups on constitutional questions, but I don't actually represent any clients or anything in that. Okay. All right. Well, hopefully that was, got another question. Yeah.
I was just wondering if we're doing Miranda rights or warnings only in the United States, or are they applicable also?
You know, that's a really good question.
World,
So the Constitution supposedly follows the flag to certain areas. That's a different constitutional question, where actually the Constitution applies outside of the United States. And the answer is wherever the United States exercises sort of de facto sovereignty for an area. So maybe Guantanamo Bay, for example. So in theory, and I don't know the exact answer to this, but put the pieces together, yes, you have to get your Miranda rights read to you if you are in an area in which the United States Constitution applies, which is an area of de facto sovereignty. Now, that doesn't apply in countries other than the United States. So if police officials go into Mexico and arrest you, you're in a different sovereign country, then the Constitution doesn't necessarily follow you there. But that's a great question. Yeah.
But what if they take you back to the American soil and then they train there?
Yeah. Well, once you're in an area of U.S. sovereignty, then the Constitution is supposed to apply from there on out, right? Now, whether or not that leads to black sites in places that are not in U.S. sovereignty or under the constitutional rule, some people think that rule is dangerous because it actually pushes these kind of interrogations into off-country sites.
Like you were an undercover cop and you were not technically in America, would that still apply?
There's actually some exceptions, and I didn't mention them, but there are exceptions for undercover cops in emergency situations like that, where they may not have to read your Miranda rights, depending on what the circumstances are. But as I've said, since about 1980, more and more sort of holes get poked into what Miranda means, and one of them deals with undercover police officers. Yeah.
I'm wondering if the police officer has intention to arrest a person who is not fluent in English language.
Yeah.
We have a lot of immigrants in the
Yes.
city. And what should do the police
Yes.
realize that the person doesn't understand even the questions
Yeah.
you understand or know?
Right.
And what should do that person who going to be detained
Right.
or arrested? And our second question is, when we have language barrier,
Yeah.
right now I saw on the news a lot of police officers, they're required to wear the body cam
Mhm.
and they start recording everything.
Mhm.
And if the police officer explain the Miranda rules,
Yeah.
maybe the person doesn't understand even the Miranda and start talking different language.
Yeah,
And
that's
they
recorded.
record that. Is that going to be allowed as evidence? in the court?
Yeah, no, so it could be recorded and not be allowed into evidence. So you could say stuff and you still get it excluded because you didn't have proper Miranda warnings. On the question of the first, let me take a couple of them. On the question of what the person should do, right? That's an easy one. Say, I want a lawyer, right? I want a lawyer appointed for me, and don't say anything else until the lawyer shows
But
up.
I'm saying different language.
Yeah, I mean, but just learn those words. is what I would say. Is what I would say. And so Miranda does require that people actually understand the rights. I mean, that is sort of the gravamen. So now what efforts police actually make, may depend on the circumstances. Can they get someone to translate this? What are the circumstances surrounding the arrest? Is there danger? Lots of things will come into the calculus, but in sort of a perfect world, yes, you should get a translator.
Can the police officer request interpreter on the phone?
I don't know the answer to that. As long as you can get, the gravamen is that you make sure that the rights are understood. And so that's the effort they have to make. And again, there are exceptions depending on circumstances. Say we can't find anybody that speaks that language in English within a certain area, then that may change the circumstance, right? All right.
Can I just ask?
Yeah, sure. We got 2 minutes left. You're good.
Like in my case with my nephew, can the police allow someone to assist them, or the police? I know they're doing their job and
Yeah.
they don't want no interference,
Sure.
But in this case, where he doesn't understand the language, he's mentally retarded,
Yeah.
can the police allow them to have somebody to explain to them the Miranda rights, or is that against the law?
Well, of course they can allow them to. The question may be whether they feel like they need to in a particular circumstance. I would say it's always better if they do, right? They should err on the side of making sure that what they're saying is understood and that people are being helpful. Now, as I said, there's exceptions. If police feel they're in danger for some reason, or then things might change. But yeah, it sounds like in your circumstance, they clearly should let the person stay and help answer questions.
Thank you.
Yeah, sure. All right, Shelley, thank you.